Mr. Smith are in the courtroom. Mr. Smith, there you go. I was going to tell you your video camera was not on yet, but now it is. Mr. Weinstein, we're ready when you are.
Yes, Your Honor. Morgan Weinstein on behalf of the appellant, along with Maria Santi. If I may, we would request 5 minutes for rebuttal and then begin. May it please the court. Thank you. Your Honor, this case should not have had to have been brought on appeal, and the reason for that is that the hearing officer at the fair hearing level utilized an incomplete statement of the law and relied upon insufficient evidence in order to make a determination based upon the prior authorization criteria at issue in this case. The most important component of that incomplete statement of the law relied upon is that the hearing officer, in issuing the order on appeal, did not consider the fact that the child had an acute reversible illness as a reason to deny or reverse the denial issued by the insurance company. The hearing officer.
Mr. Weinstein, this is a very sad case. Your opponent has moved to dismiss for mootness. Has your client, has the child received this medication?
The client has received this medication. The client also continues to be on Medicaid. The client continues to require Medicaid services in the future for an additional 19 years. And the client will, at some point in the future, likely require another prior authorization criteria review based upon his treating physician.
You've gotten the relief you've requested.
We have not gotten all of the relief you requested, respectfully, Your Honor. We've gotten the relief
what's left? Fees?
And a determination that this appeal should not have had to have been brought in the first place because ACCA should have engaged in a review that did not rotely reapply the prior authorization criteria, and in doing so only reapply a portion of the prior authorization criteria.
Well, I understand your argument, but I think you're at a disadvantage because unfortunately the mother had to proceed pro se. But fortunately, she had some very competent experts to testify on her behalf. But what the record is devoid of is no one testified that he had an acute reversible illness at all.
In fact, Your Honor,
it's not in there.
The treating physician testified that the child had RSV and that the child had a rhinovirus. The treating physician also testified that the child was recovering from both of those acute overlapping reversible illnesses.
On the date that he testified, sir, the child had been on the ventilator for 74 days. And Dr. Finkel testified he's not completely free of pulmonary infection.
Yes, Your Honor.
He had been extubated only twice, and each time the extubation time got shorter. And he clearly testified, both he and Potts testified, he does not fulfill the criteria at all. Now, this was an emotional, sympathetic plea. But he testified he was also an author of the criteria for a similar drug. And he also agreed that the criteria applies to this drug that I don't know how to pronounce. But he also testified it's impossible for AG to be in perfect health because he's intubated. He's in ICU, and there's a high risk of treating him with this drug. But also the drug warning label says it's not safe for somebody who's been on permanent ventilation.
Your Honor, respectfully, the authorization notes at page 126 of the record indicate that the hospital was attempting to wean, but feel due to his deconditioned status secondary to his RSV, this, quote, may take some time. The authorization notes also state that it would not be possible for him to receive extubation, quote, at this time. And those statements are indicative of the acute reversible illnesses that we are discussing. When you're talking about the fact that he hasn't recovered from the pulmonary issue, it was that he hadn't recovered yet. It's not that he wouldn't recover or that recovery would be impossible. There could have been a determination that Zolgensma would have been available for the client once he had recovered from his acute reversible illnesses, if that happened. And so the ventilator support, and this is the other component of the definition or the policy that was mistakenly applied in the final order, Your Honor. The final order reasons...
The issue that you're arguing now, was that ever raised below?
The treating physician certainly testified that the child had acute reversible illnesses by testifying that he had the RSV and the rhinovirus and had not yet recovered from each of those. Yes, Your Honor.
Show me where that is in the record, because if he authored the criteria, he would have referred to the criteria. This hearing officer, I'll give him credit, he was very inquisitive. asked many questions of Dr. Finkel. And Dr. Finkel said he didn't meet the criteria, which meant he did not have an acute reversible illness, sir. I don't know
Believe
how
that
you're
if
reading
I'm
that in here. And what Judge Silberman
if
is saying is the mother had the burden of proof to raise these issues. Now, you've done a good job, but we're stuck with the record that we have.
Yes, Your Honor, and the record that we have indicates that pages 366 and 367, which are part of the reasoning that the hearing officer provided, that Dr. Finkel did not establish what that would be. However, petitioner's current medical condition is compounded by the fact that there is still inflammation and mucus buildup in petitioner's lungs from RSV and rhinovirus. That's in the final order. If that's the case, and the definition utilized by ACA, the prior authorization utilized by ACA, says that if you have an acute reversible illness, then you do not have the ability, ACA, to deny the child this treatment.
Those words were never used below, sir.
I'm looking at pages 366
That
and
is your interpretation.
the final order says, quote, Dr. Finkel did not.
What paragraph are you looking at?
I'm looking at paragraph 33 of the final order on pages 366 through 367.
Stop for a moment. So you keep talking over us, and I know it's a little bit difficult because of the virtual nature. You need to pause and let us ask our questions and not argue while we're making the question. Do you understand?
I've been in front of Your Honor a number of times. It's also because of the sensitive nature of this case, and I apologize for that. Sorry.
I understand, but I also understand with the remote courtroom, it's a little bit difficult. So I just want to let you know we're not going to make progress if we're talking over each other.
Understood, Your Honor.
So I'm looking at paragraph 33 of the order right now.
If you look at the last sentence on page 366, Dr. Finkel did not.
Dr. Finkel did not establish what that would be. However, petitioner's current medical condition is compounded by the fact there is still inflammation and mucus buildup, which may persist for several weeks. So that is the statement in there. Did Dr. Finkel or anyone else say that your client was capable of receiving this medication at this point? Or did they say that, no, he didn't meet the criteria?
They said that he did not meet the criteria at this time. And the reason...
So let me ask then, was this issue that you are now arguing brought to the attention below of the hearing officer that, wait, there's a problem, you had made this finding, it is not consistent with the testimony, or it is consistent, but there's a problem with the finding?
Did the petitioner file a motion for rehearing in this case? No, but this issue appeared for the first time on the face of the final order, Your Honor, because the testimony below was that there is an acute reversible illness. In fact, there are two. It's acute because it's currently ongoing but won't be forever, and it's reversible because eventually he will be done with it.
So isn't there?
But sir, at the time, go ahead.
Hang on, finish, Judge Sleet. Isn't there a failure to carry the burden by your client in not eliciting from the witnesses that, wait a second, there is an exception and we need to get this drug as soon as that exception is fulfilled?
No, Your Honor. Respectfully, in my opinion, there's not, because it's not an exception. It's a component of the rule that would allow them to uphold the denial. And so it is the burden of proof. It's the burden of proof of the petitioner to establish that the plan was wrong in issuing the denial and then upholding the denial. But it's the burden of the petitioner presented sufficient evidence that that was the case, because a component of the definition used to justify the denial was not met. It's not that there's an exception to when you have advanced SMA. It's that you don't have advanced SMA if you have an acute reversible illness, because there is no ability to determine whether you do, in fact.
Unfortunately, no expert testified to that effect.
Well, no, it's the definition itself. The definition at page 351. If you look at page 351 of the record and you look at the...
We understand what it says. The question now is whether the evidence established what you are saying. And it seems to me the doctor's testimony does not establish what you were saying. I understand what the testimony was, and we've all read this, but ultimately the conclusion of the experts was they were consistent that your client was not meeting the criteria to get this drug.
Your Honor, the testimony was consistent that the child was not meeting the criteria as it was being discussed at the fair hearing, which included a discussion that involved the definition, first of all, requiring that my client be free from ventilation 8 hours per day, which is not what the definition
Aren't you
says.
essentially asking us to fill in a gap in the evidence?
No, Your Honor, I don't believe that I am. And the reason that I don't believe that I am is because of the definition. The definition needs to be strictly construed because it's a prior authorization criteria, and we cite all of the cases that talk about that. And the definition says if you have an acute reversible illness, there is no ability for the plan to determine that there is a lack of medical necessity, and there's no ability for the insurance company to uphold on appeal of that plan, on the plan appeal, that there is a lack of medical necessity.
Well, let's look at the history of this case to show that it's not an acute reversible illness, okay? He's on invasive ventilator 43 out of 45 days when Dr. Finkel prescribes the drug. He's on the ventilator for 51 days when it's denied. He's been on the ventilator for 74 days when the hearing occurs. There's no evidence whatsoever that is a reversible acute illness, nor does Dr. Finkel ever say those words that you are trying to tell us were said or implied at the hearing. Dr. Finkel was honest. He made a sympathetic plea to try to save the boy's life, but he also acknowledged that there was a very high risk in giving him this particular drug at that time. And no one could opine when and if this child could ever be off the respirator for 14 days, 16 hours a day. Correct?
Yes. No, Your Honor. I would point again to the authorization notes at page 126 of the record. Those authorization notes indicate that, in fact, he would recover from the acute reversible illnesses, but it may take some time. And so total extubation would not be possible at this time.
But those authorization notes were done before the hearing.
I believe, if I remember correctly, the day before.
Right. And at the hearing, they testified, medical experts testified that they don't know if he'll ever be able to live without a ventilator in accordance with these criteria.
Dr. Finkel testified that he had these acute reversible illnesses. He testified that he had RSV. And so the thing that I struggle with here, Your Honor, and if I'm being candid, the thing that I struggle with here is my interpretation of what the the guideline says, what the prior authorization criteria says, means you can't, as the plan, determine that there is advanced SMA while these acute reversible illnesses are ongoing. And the reason that you can't determine that is because we don't know who the villain is. We don't know whether he's on ventilator support because of these acute reversible illnesses or because of the advanced SMA. And so if we can't make that determination because the acute reversible illnesses have not played themselves out, you cannot issue a denial on a request for Zolgensma based upon medical necessity because we don't know whether the child has advanced SMA yet. They didn't fulfill the condition precedent to establishing that there was advanced SMA with my client that would have allowed them to issue the denial in the first place. And so that's the point that we're making when we're talking about the insufficiency of the evidence to uphold the denial. And we're talking about the fact that they're relying upon a partial definition where the final order indicates that there were these acute reversible illnesses and then nevertheless says there was permanent ventilator dependency. You can't find permanent ventilator dependency when there are acute reversible illnesses because you don't know whether the acute reversible illnesses are the reason for ventilator dependency in the first place. And obviously, as we know from this case, they were the villain because the child eventually got over them and was able to get the treatment and is doing successfully.
That's outside the record, sir.
It's in the suggestion of mootness, if I remember correctly. Your
Well,
Honor.
you objected to what the opposing party submitted and filed in their motion to dismiss for mootness. You objected because it's not in the record, but now you're arguing that.
Your Honor, I objected because it's not in the record.
You can't have it both ways, sir. And I'm trying to figure out why this appeal is still pending and you're incurring fees for an indigent person when they've already gotten the drug.
Your Honor, this appeal is still pending. I mean, the insurance.
For what reason?
We need a determination so that things like this don't happen again.
This is such a unique situation, and he has such a debilitating disease. There's no way we can tell if this recurs, sir.
It has recurred in this system. We've settled a couple of these cases before, and that's outside the record too, Your Honor. But the reason that the case law states not only that, it has to be the same person, but if the question could come up again, if the issue could come up again, there are multiple cases that we cite in the initial brief and in the reply brief that discuss this. It's not specific to the patient. It's specific to the issue or the question posed.
Mr. Weinstein, just let me know you can finish answering Judge Sleep, but as soon as you finish that answer, you'll be cutting into your rebuttal time.
Yes, Your Honor, and thank you for that. If the question posed or if the issue could recur, then the issue is not moot. That's the capable of repetition yet evading review portion of mootness. This issue is capable of repetition because ACCA continually promulgates prior authorization criteria, whether related to Zolgensma or not, and rigidly reapplies those prior authorization criteria in denying services to Medicaid patients, particularly under the EPSD. Under CF and EB, it's not allowed to do that.
Very good. Thank you, Mr. Weinstein. Mr. Smith?
Thank you, Your Honor. May it please the court. My name is Craig Smith. I represent the appellee, Simply Healthcare.
Mr. Smith, do me a favor. Turn off your audio and turn it back on. We're getting a little bit of weird feedback. Go ahead and say something. Let's see if that will fix it once it's back on.
Okay, how is that?
You might just need to speak louder. Hopefully we'll be able to understand. If I can't, I'll let you know.
The court should either dismiss this appeal based on mootness.
We're going to need to find an option because it is really breaking up. We may need to have you call in with audio. You can keep your camera on, but you might need to call in with your phone.
Okay, I'll try one other. Is that any better?
Now it's very faint. I think you're going to need to call in.
Okay.
Say something. Hang on. Say something again. Let me hear you.
Testing.
That seems to be better right now.
Okay, thank you. The court should either dismiss this appeal based on mootness, or the court should affirm the final order because the hearing officer correctly applied the standards. And there's two real reasons here, Your Honors. First, this appeal is moot, as Judge Sleet noted in the questioning. This appellant has received the Zolgensma treatment. It is therefore moot. This is a single dose, once in a lifetime treatment. It's not a treatment that you get repeatedly over a lifetime. It's once in a lifetime. The good news is that that AG's condition improved over time, and he was able to get the treatment covered by the state of Florida, and that's good news. But that also explains why this appeal is moot. Second, the Medicaid Fair Hearing Officer did a very good job in questioning the witnesses at the hearing and did a very good job in writing a detailed 17-page opinion that correctly relied on the testimony of the medical experts who appeared at the hearing. As Judge Sleet noted, Dr. Finkel, the treating physician, he has used Zolgensma for patients before. He testified that in those situations, the patients met the criteria and it was safe for them to use Zolgensma. But here, Dr. Finkel and Dr. Pott repeatedly testified that AG was not in a medical condition for Zolgensma to be safe, in particular because he was on permanent ventilation for all of the days that Judge Sleet outlined in his questioning. So for those reasons, this appeal should either be dismissed or affirmed. Let's go back to mootness for a second. The appellant requested a single type of remedy in their initial brief. They asked for this court to reverse and remand to the agency for the entry of a final order for the coverage of Zolgensma for AG. That relief has already been granted. The agency has covered Zolgensma. It is a once-in-a-lifetime treatment, single dose. That has already occurred. And for that very reason, the appeal is moot. Another interesting thing that occurred while this appeal was pending is that AG voluntarily switched health plans. He disenrolled from Simply Healthcare, my client, and enrolled in a different Medicaid managed care plan. At that point in time, under Medicaid rules, AG could have requested that the new Medicaid health plan cover the Zolgensma at that point based on his new medical condition. His condition back in February, at the time of the fair hearing, no longer would have mattered. If he was off the ventilator at that time, he could have asked the new Medicaid health plan for coverage. But instead of doing that, we just continued this appeal for months and months and months. And I submit that it was only because there was a pending motion for attorney's fees once the child received this Zolgensma treatment that this appeal continued. But we know from the first DCA's opinion in the Lund v. HRS decision that is cited in the briefing that a request for attorney's fees under 120.595 for an appellate level attorney's fees based on gross abuse of discretion is not a collateral consequence that defeats mootness. The first DCA was very clear and answered that directly. And for all of those reasons, this appeal should be dismissed based on mootness.
Mr. Smith, I want to ask a question relating to the merits and the doctor's testimony. The doctor's testimony was that he did not qualify to receive this particular treatment at the time. And Mr. Weinstein is arguing that the final order is incorrect because it doesn't recognize the language in the absence of an acute reversible illness. But as I'm reading the criteria, the patient would still not be qualified. If there is an acute reversible illness, the patient would still not be entitled to get the drug until that reversible illness is resolved. Am I reading that correctly?
Yes, it's a prior authorization criteria that is designed because this is a once-in-a-lifetime treatment. It's designed to make sure that the patient is in a safe medical condition so this treatment has a chance to work. And so you're exactly right. If they're on permanent ventilator dependence, as Dr. Finkel and Dr. Pott repeatedly testified, then they cannot meet that criteria at that time. And look, I wasn't involved in the Medicaid fair hearing, but when I read this transcript, it seems to me that what Dr. Finkel is trying to do is make a sympathetic plea that for Medicaid to cover this drug at a future date, some later point in time, when the child's health condition improves. Dr. Finkel very clearly says, look, he's on ventilation because of his SMA condition. I can't rule out the possibility that maybe there's some level of contribution from a virus, but in my medical opinion, it's the SMA that is causing him to be on this ventilation.
If the doctor would have testified that he doesn't presently meet criteria because he has an acute reversible illness as well as his other problems, and would the hearing officer, would the order be different? Because it seems to me the hearing officer's order would either be basically the same, or it would say he doesn't meet criteria at this point because he's got an acute reversible illness, but if and when that is cleared up, then the drug shall be given. I mean, are those basically the two options that the hearing officer could have had?
The hearing officer only had one option, which was to enter an order ruling that it was not, that the petitioner had not met his burden of proof to establish that the drug was medically necessary at that time. And here's why. Under Medicaid fair hearing rules, as soon as that final order gets entered, the petitioner has the opportunity to request coverage of the drug right again. They request it to the Medicaid health plan. The Medicaid health plan reviews the updated medical condition, the updated information, makes a decision, and if it's denied again, it would go to fair hearing again very quickly on a new record. There would not be a need for a hearing officer to enter a conditional order like that, because the future facts would not be known. Those would come up in a subsequent.
Am I understanding then that your position, it sounds like from what you just said, your position is based on this evidence, there's nothing wrong with the order that was entered. And if there was evidence of an acute reversible illness, which Mr. Weinstein says there was evidence of, then as soon as that illness was cleared up, if and when that happened, then the patient would be entitled to again demand the administration of the drug, provided that the doctor has agreed, yes, now he meets criteria.
Yes, and the way Medicaid fair hearings work and Medicaid requests for coverage of services to Medicaid health plans work, or under the Medicaid fee-for-service plan, the child would not have even needed to wait until the condition approved. The child could have asked for coverage immediately the same day the final order came out, and could have hoped that the condition was improving by the time the decision was made. And if a denial was issued again, then by the time of the fair hearing, one would hope that he would be off permanent ventilation and would be capable of having safe treatment with the Zolgensma. But the worst thing you could do is give a person Zolgensma, which is a once in a lifetime treatment, one time when they're not safe. And Dr. Finkel testified repeatedly about the risks of giving him Zolgensma at that time. A couple other points, Your Honors. There are arguments that appellant has raised that somehow the hearing officer misapplied the Medicaid EPSDT standards. We've briefed that issue in detail, but it's quite clear that both the Florida legislature and Congress, as well as the federal Centers for Medicare and Medicaid Services, have given state Medicaid agencies like the Agency for Healthcare Administration broad authority to establish medical necessity and medically necessary standards for these types of services. And ACA is well within its right to do that here. Most importantly, ACA's prior authorization criteria is entirely consistent with the manufacturer's product labeling for Zolgensma. It has tracked it very clearly. The manufacturer says this product, there is no testing and no evaluation of the safety or efficacy for Zolgensma with children who have advanced SMA and who are on permanent ventilation. And that's consistent with the agency's criteria. And so in that sense, appellant's argument must fail. Notably, however, appellant did not even raise that argument below. In fact, to the contrary, the doctors who testified for appellant, as Judge Lee noted, very candidly embraced the criteria. Dr. Finkel was an advisor to the manufacturer of Zolgensma. He helped the agency develop this criteria. He endorsed it during the hearing, and he applied it and determined that AG did not meet the criteria, and it was not safe at that time for him to have his Zolgensma treatment. So for all of these reasons, we ask that this court either dismiss the appeal or, and that's based on notice, or affirm the final order that the hearing officer rendered. If the court has any other questions, I'm happy to answer them.
Very good. Thank you very much, Mr. Weinstein. 5 minutes for rebuttal.
Yes, Your Honor. Your Honor, if this appeal is moot, then what the plans get to do is they get to issue a denial to a pro se person, and then they get to, upon a plan appeal, if that pro se person proceeds to a plan appeal, uphold the denial. And then if that pro se person somehow finds themselves in a fair hearing, they get to uphold the denial. The ACA gets to uphold the denial and thus not have to pay the plan to pay for the service. And then only if somehow that pro se person finds an attorney or files an appeal by themselves, which unlikely in most cases, which is why we don't see a lot of these appeals, does this issue get heard. This is the reason that capable of repetition yet evading review exists. It's the reason that the Matthews Court, in talking about that, says that if the, quote, problem or, quote, controversy is likely to recur, then you should hear the issue. It's why the Gould Court says that when the, quote, petition presents a question capable of repetition yet evading review, the issue should be heard. Under
Well,
the current,
it doesn't appear that your client got this drug simply because you represented her. These agencies got together and decided he was approved. So it wasn't because you got involved.
Your Honor, I don't know that it's because I got involved.
Well, that's
I
what you're
wouldn't
saying.
say that I'm the reason.
No, you're
I'm
saying
saying
that
that
it
the
takes
fact that there is-
lawyers to get involved in these cases to make these agencies approve it when they did it without you.
Lawyers and judges, Your Honor. The fact that these cases can be heard before judges and that there is DCA recourse, which can create precedent, which makes it so that they have to do this at the fair hearing level. Yes, Your Honor. That is incredibly important and creates a propulsive effect in terms of making it so that these plans and ACA actually provide the treatment before the fair hearing level and at the fair hearing level so that these appeals don't have to be taken. Yes, absolutely. Absolutely, that's our position. Because what we have now is a system where that doesn't happen for the most part, that you have to somehow luck into finding a lawyer as a pro se person who's gone through this process and is overwhelmed by everything that's going on in your life when you have a child who has something like Zolgensma or like SMA or another life-threatening or debilitating illness. Yes. And Your Honors, one thing that we haven't talked about in the first part of my presentation is the fact that while this case was ongoing, the 4th District Court of Appeal in QH, which we filed as supplemental authority, ruled that their definition of medical necessity, that the definition of medical necessity employed in this case in the final order by the fair hearing officer at page 356 is inappropriate when there is an EPSDT benefit claim. And so because this child has claimed an EPSDT benefit, because the final order uses the more restrictive definition of medical necessity, even taking out that the prior authorization criteria may or may not have been valid. Even if the prior authorization criteria is generally valid, the use of the Rule 1.010 medical necessity definition in an EPSDT case is prohibited. And that was true in the 3rd and 4th DCA before QH came out. And then just 2 months ago, the 4th DCA, in a lengthy opinion that is well-reasoned and cites CF and cites EB and talks about the entire framework that we're talking about, in this case, the exact same framework with the exact same definition in an EPSDT case, said you can't do that. There's no ability for a hearing officer to utilize the definition of medical necessity under Rule 1.010 when the claim is for an EPSDT benefit, because the EPSDT benefit is supposed to be able to correct or ameliorate a condition and is not supposed to have that more restrictive requirement, such as, quote, must be individualized, specific, and consistent with symptoms or confirmed diagnosis of the illness or injury under treatment and not in excess of the patient's needs, unquote. That is not a component of the EPSDT, and Florida courts at the district court level, including the 4th District just 2 months ago, have stated that definition is inappropriate in a case exactly like this case. An EPSDT case.
Do we get to apply this new analysis when it was not raised in this case?
Your Honor, the reason that this analysis, well, the analysis was raised in this case, Your Honor. We went through the same analysis in the initial brief in our discussions of the CF case, which is also out of the 4th DCA, and in our discussion of the EB case, which is out of the 3rd DCA.
That was not raised below, correct? The challenge to the definitional structure was not raised.
A challenge to the definitional structure of medical necessity was not raised below because it could not have been raised below, because our challenge was a constitutional issue with regard to that. And in an administrative hearing, you cannot raise those challenges below. That was briefed in this case as well. There is no ability for the hearing officer to pass upon that type of constitutional determination. And so the recourse, the first time you have recourse with regard to such a constitutional issue, whether this definition promulgated by ACA in the rules is permissible under the rulemaking authority of the statute, that's an issue that can only be raised in the DCA and then above, because there's no judicial body at the fair hearing level.
Unless the panel has other questions, you have 30 seconds to wrap up.
Your Honors, in this case, we have an issue where there was an acute reversible illness, which means that the definition enabling the insurance company or the plan to deny the benefit was not yet triggered. We also have a case in which there is this issue with regard to QH and whether the medical necessity definition is overly restrictive. That's not really an issue because all of the courts have said that in the context of the EPSD, yes, it is. And so they could not have used the definition that they used of medical necessity under the administrative code. Further, we have an issue that hasn't been discussed but has been briefed, which is that saying that having advanced SMA, which causes respiratory ailments, is a reason to not give a drug which prevents respiratory ailments, is using the diagnosis or disease and discriminating on that basis. The EPSDT also prohibits that, and we've cited the authority to that end.
Very good. Thank you very much, counsel. We appreciate the help on this case. That will conclude the oral argument session for today. We are adjourned.